Judge Ginsburg, they're really making you sit away from DC? I asked to speak just so I wouldn't have to wear a mask for at least part of the day. Good afternoon. I'm Barry Nigro, Principal Deputy Assistant Attorney General for the Antitrust Division. Thank you for joining us today for our presentation of the Sherman Award to the Honorable Douglas Ginsburg. On behalf of the Antitrust Division and the Department of Justice, I want to extend a warm welcome to all those attending virtually, including our attorneys, economists, and staff, as well as the many friends of the division and of Judge Ginsburg. I also want to welcome the guests we have in person, including Judge Ginsburg, his wife, Ms. D.C. Gray, and other family watching remotely. It's a special privilege to recognize our guest from the United States Supreme Court, Justice Gorsuch. It's an honor to have the Justice with us for this special occasion, so welcome. We are also joined virtually by many distinguished guests, including former Attorney General under President Ronald Reagan, Ed Meese, and the Honorable C. Boyden Gray, who was the ambassador to the European Union under President George Bush, among other accomplishments. We welcome Commissioners Rohit, Chopra, and Noah Phillips from the Federal Trade Commission, as well as Chairman Heath Tarbert of the Commodities Futures Trading Commission and a former clerk of Judge Ginsburg's. Other esteemed guests include recipients of the Sherman Award from years past, such as James Rill, with whom I've had the pleasure of working and knowing well since 1988. The son of Robert Potofsky, David Potofsky, also is joining us virtually today, and there are too many others to name. The Antitrust Division has been looking forward to this celebration in honor of Judge Ginsburg for a long time. Although many things have changed since we first announced this event, including the first pandemic of my lifetime, it remains a great pleasure for us to pay tribute to this giant in our field of antitrust. Let me begin the ceremony with a brief description of Judge Ginsburg's distinguished career. Judge Ginsburg was appointed to serve on the D.C. Circuit in 1986 by President Ronald Reagan. He served as its chief judge from 2001 to 2008 and assumed senior status in 2011. Before joining the bench, Judge Ginsburg went to Cornell University and received a JD from the University of Chicago Law School in 1973. He subsequently clerked for Judge Carl McGowan of the D.C. Circuit and then for Justice Thurgood Marshall of the U.S. Supreme Court. For the following several years, he taught as a professor at Harvard Law School. He then served as the Deputy Assistant Attorney General for Regulatory Affairs and the Antitrust Division, as the Administrator of the Office of Information and Regulatory Affairs in the Office of Management and Budget, and then as Assistant Attorney General in the Antitrust Division from 1985 to 1986, before his appointment to the D.C. Circuit Court of Appeals. Concurrent with his time on the bench, Judge Ginsburg taught at several law schools, including Columbia University and New York University. He is currently a professor of law at the Antonin Scalia Law School of George Mason University and a visiting professor at the University College London. Our Assistant Attorney General, Makan Delrahim, with whom I have had the pleasure of serving for more than 3 years, will give further remarks in short order about Judge Ginsburg's many invaluable contributions to antitrust law and in public service. But first, I would like to invite Fred Young to sing the national anthem. Some of you may know Fred as a trial attorney from the telecommunications and broadband section of the Antitrust Division. But he is also a talented singer and the lead of the Antitrust Division's a cappella group, the Coordinated Effects. Unfortunately, due to space limitations for in-person gatherings, we have only Fred with us today. So I haven't told you this, Fred, but I've renamed your group for today, for purposes of today, the Unilateral Effects. So thank you, and please rise for our national anthem.
Oh, Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rocket's red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say, does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Thank you again to Fred for that rendition of the national anthem. I hope he didn't miss the other members of the coordinated effects too much, but as we've all just heard, I think this just goes to show that unilateral effects on their own can also be quite powerful. I'm Cecilia Chang, a Rill Fellow and attorney at the Antitrust Division. I also am one of Judge Ginsburg's former clerks and just finished my clerkship prior to joining the division last year. Today, I have the good fortune of speaking on behalf of Judge Ginsburg's prior clerks in tribute. Two other former clerks of Judge Ginsburg currently work at the division, Taylor Owings, the Chief of Staff to the Assistant Attorney General, and Daniel Haar, the Chief of the division's Appellate Section. What I will say this afternoon draws on stories by us and by other former clerks who have shared fond memories for the happy occasion. I'd like to use these stories to highlight three of Judge Ginsburg's qualities which have stood out to all of those who have the great privilege of working with him or for him in some capacity. First, it is clear from Judge Ginsburg's over 30 years of service on the federal bench that his devotion to the law and to justice is unwavering. Judge Ginsburg is steadfast not in ideology or dogma, but in commitment to justice for all. To illustrate this, I'd like to share some words from Joe Bile, who is with us in person today. In Joe's words, I was fortunate to clerk during a high-profile year when we had the Microsoft case in chambers, and Judge spent much of his time on this complex and challenging case. Be that as it may, it is a different case that I remember most, a simple, seemingly straightforward criminal case, and the judge spent just as much thought and preparation on that one. It was a case of misidentification, and the judge questioned the DOJ's lawyer extensively about inconsistencies between the factual record and the government's account. Ultimately, the judge dismissed the defendant's sentence. It remains the proudest moment of my clerkship to see the judge's complete devotion to justice to all parties before him, unquote. Anyone who has read Judge Ginsburg's opinions will find his turn of phrases impressive and the writing unimpeachable. But what stands out most from his opinions is his ability, maybe honed through his hobby of fox hunting, to strip away the rhetoric and target with precision the key issues at hand. No matter which litigant is before him, Judge Ginsburg has no tolerance for intellectual laziness, and his commitment to rigorous analysis is relentless. I called a local fox hunting club to see if they could help me illustrate this point using terms that would resonate with the judge, and this is how they told me the masters would put it. Judge never draws blank, but instead immediately follows the cry to ground, sometimes with us clerks as whippers in, or more likely as hounds. Maybe the judge can tell us all after the ceremony what that sentence meant. Judge Ginsburg's dedication also is illustrated by his tireless energy, which we all saw daily. Even when he was traveling the globe to give a speech or to train foreign judges, we would often get faxes back from Istanbul or Brazil of the next draft article or speech marked up, reminding us that the sun never sets on important work. Daniel Haar, who clerked for him the year of the Virginia earthquake, has a memory that underscores this attribute. When the earthquake struck, it was strong enough that his two co-clerks, who, unlike Daniel, knew what was happening as they had lived in California, immediately sought cover, and they had to tell Daniel to get under a table, too. After the tremors abated, the courthouse suggested everyone leave the building so experts could test its structural integrity. Daniel and his co-clerks let Judge know that they'd be following the recommendation. "I'll be staying," replied the judge. Of course, he had work to do. Second, we have all admired Judge Ginsburg's excellent sense of humor, which he deploys in good times and in bad. Early in my clerkship, the judge and I stayed up one weekday in advance of an important presentation of his, which required immense preparation into the early morning. I remember neither of us slept a wink. The next day, however, when I asked the judge how his remarks went, he did not answer directly, but instead told a story about General Eisenhower and military battles in Alsace-Lorraine. I won't repeat the full story here, though of course, Judge told it in vivid detail. It ended with this moral, which Judge quoted in spirit from General Eisenhower. "It is not the plan that counts, but the planning." From this, I gathered that maybe none of the preparation we did the night prior was used as intended. And the judge ended up improvising his presentation on a different topic, though still informed in some inexplicable way by the prior night's work. I remember the story for the wisdom it related, and more relevant today, what it showed about the judge. Judge Ginsburg's good humor and flexibility are hallmarks of his character. The story also reflected the judge's passion for learning, which holds its own reward to him. I believe it is this view which allows Judge Ginsburg to be creative in his approach to legal questions. Former Deputy Attorney General Rod Rosenstein shared a memory that shows how alert Judge Ginsburg's mind is to the needs of the moment. Former DAG Rosenstein recounted a time during his clerkship when the judge was ruling on whether simple graphical elements involved in a video game could be copyrighted. To help settle that dispute, the judge ultimately sent then-clerk Rosenstein to the National Gallery to pick up a print of a painting by the abstract artist Piet Mondrian, which the judge then used to demonstrate that a collection of geometric shapes can indeed amount to original art. Finally, the judge cares deeply not only about justice and intellectual rigor, but about his family, his clerks, and the next generation of antitrust lawyers and thinkers. As clerks, many of us can speak to judges' generosity as a mentor. Many go on to work in antitrust law and spend much of our career in public service at the Department of Justice or the Federal Trade Commission, which is a testament to judges' ability to tend to the budding interests in the antitrust laws. It has, unfortunately, however, led to a situation where the DOJ and the FTC have become a duopsony of Judge Ginsburg clerks, or an economic condition in which there are only two large buyers for a very specific product or service. I should clarify that was an overstatement, as Daniel Haar informs me the agencies likely have only under a 20% share recently. So thank you, appellate section. From the judge, we have learned that good writing is concise, that a simpler word is often preferable to a more elaborate one, and the grammatical sin of splitting an infinitive is one we learn to never commit. Oops. In addition, we have learned much about how to persuade and about the importance of calm in advancing a position. Though all clerks will say that Judge Ginsburg is a demanding boss, he is always the model of courtesy. Judge Ginsburg relies purely on his reason in advancing his position and never disheartens those who work with him. As a result, those who have worked with him feel as comfortable in disagreement as in harmony, as long as the reasoning is sharp. Michael Williams, who clerked for Judge Ginsburg in 2001, sums all of this up quite well. It seemed almost as if there were two sides to Judge Ginsburg. On the one hand, there was the kind-hearted teacher with an easygoing sense of humor and gentle disposition. On the other, there was the ruthless master of the written word, who shredded my drafts with a scalpel, a stiletto, and on a few occasions, a hatchet. The former was genial, engaging, and patient. He drank a cup of decaf coffee in the afternoon. On many days, we ate frozen yogurt together. The latter was terrifyingly efficient and precise. I received binders of pages that were covered in red ink. There was never, not once, a single page left unscathed. The questions in the margins always cut to the heart of the issue with relentless economy. The most daunting of them all, a lonely question mark. When I began clerking for Judge Ginsburg, I had thought I was a gentleman and a capable writer. The judge showed me through his example how much room there was for me to improve in both respects," unquote. All these qualities combined make the judge a mentor any person would wish to seek in her career. Those around Judge Ginsburg strive to improve for a desire that they too can use what they've learned to make him proud. Certainly this was true for Taylor, Daniel, and me, and it was also the case for the many former clerks who had planned to come to this ceremony before the COVID-19 pandemic sent these plans awry. For these reasons, on behalf of his clerks who could not be here in person, and on behalf of those in the room today, we cheer to see this recognition of a great mentor and a great judge. With that, please welcome our Assistant Attorney General, the Honorable Makan Delrahim, who will share more of Judge Ginsburg's invaluable contributions to the law and to the Antitrust Division. Thank you.
Well, welcome to the Conference Center of the historic Robert F. Kennedy Department of Justice building. It's a distinct privilege for me, and one of the privileges that comes with this job, to present the Sherman Award to a great mentor and friend, Judge Douglas H. Ginsburg, this afternoon. I should also say that I have to thank you for the two ladies sitting right behind you, who have been just incredible jurists, two of your former clerks. Two of the best calls I got after being nominated was one from two friends, one Judge Ginsburg, the other from Judge Leon, who's still a friend, about one of their recent clerks, which was Taylor Rowling, and we're just pleased and honored, and I am personally, since creating the Rill Fellowship at the front office, obviously named after the great Jim Rill, for new, young, promising honors attorneys who get to come in for a fellowship, and Cece is the inaugural one. We're on our second and selecting our third now, so please send us your clerks. We're joined today by Judge Ginsburg's wife, DC, and many of Judge Ginsburg's colleagues and admirers, as Barry mentioned, and I'm particularly honored by the presence of Justice Gorsuch, a champion of liberty, who in his short time on the Supreme Court has reconfirmed his reputation for brilliance, clarity of thought and expression, and for holding the government to its word, whether in the statutes that it enacts or the treaties that it makes. I also welcome the many distinguished guests who are with us, some of my predecessors, as well as a number of folks who I will not name, just out of the fear of missing some of the others. The Sherman Award is the Department of Justice's highest antitrust honor. It is named for Senator John Sherman, who authored our nation's first antitrust law, the Sherman Act, in 1890. Today, we honor Judge Ginsburg's lifetime contributions to antitrust law and economic liberty. I can think of no more deserving recipient of the Sherman Award than Judge Ginsburg. And unlike the Oscars or the Emmys, where it's forced every year and somebody has to receive one, somebody doesn't have to receive the Sherman Award, and we have been planning this for Judge Ginsburg for a couple of years. His career in public service and his scholarship have shaped the way that antitrust law is understood and practiced. The ceremony today recognizes Judge Ginsburg's rightful place among the giants of antitrust law who have previously been given this honor. They include Judge Diane Wood, Assistant Attorney General Jim Rill, former Chairman, the late Robert Pitofsky, Professor Hovenkamp, Judge Robert Bork, Judge Richard Posner, and Professor Philip Arita. The Antitrust Division has a personal connection to Judge Ginsburg. Before he was appointed to the DC Circuit in 1986, he was the Assistant Attorney General for the Antitrust Division. This was a critical time in the division's history. At the beginning of 1984, pursuant to a consent decree, the bell system was broken up into the 7 baby bells, now better known as just the 2 bells. Judge Ginsburg had to oversee the enforcement of that consent decree, and by all accounts, discharged those duties admirably. Judge Ginsburg was central to another of the most significant moments in modern antitrust history. he was part of the en banc DC Circuit that issued the United States versus Microsoft decision, arguably the most important and influential Section 2 decision of the 21st century. The Microsoft decision also reflects a hallmark of Judge Ginsburg's work, his advocacy for intellectual property rights. Judge Ginsburg has advanced the view that strong IP rights ensure incentives to compete dynamically on innovative solutions. In Microsoft, the DC Circuit declined to find that Microsoft violated Section 2 by refusing to allow computer manufacturers to alter the Windows desktop interface. As the per curiam opinion put it, quote, "A shell that automatically prevents the Windows desktop from ever being seen by the user is a drastic alteration of Microsoft's copyrighted work and outweighs the marginal anti-competitive effect of prohibiting the OEMs from substituting a different interface automatically upon completion of the initial boot process," end quote. Judge Ginsburg's antitrust accomplishments, however, extend far beyond his career in the federal government. He is one of the foremost scholars of antitrust law. His scholarly work has shaped my thinking in numerous ways, and as I've said many times, if I'm not on the same page as Judge Ginsburg is, it's my duty to go back to page 1 and reread the book. I'll give a few examples. Judge Ginsburg co-authored an important study comparing the efficacy of generalist courts with specialist courts when the courts have to decide competition law cases. Judge Ginsburg's nuanced study notes that specialist judges have important advantages over generalist judges. After all, antitrust law is complex, and judges deciding hard antitrust cases have to understand both economics and antitrust doctrine. But Judge Ginsburg also notes that there are particular disadvantages associated with specialist courts, such as the risk of regulatory capture, where a powerful interest group may advocate for judges who serve its interests to be appointed to the court. I found this article to be convincing and valuable. I was not a fan of specialist courts. I found this valuable so much so that I'm now an advocate of the model of specialist antitrust tribunals that Judge Ginsburg suggested in that article. He noted in the article that through clever institutional design, you can ameliorate some of the disadvantages of specialist antitrust courts. And after 3 years in this job, I agree. I support an Article III court into which generalist Article III judges with an interest in antitrust law could rotate for a number of years. Industry players wouldn't play a role in selecting the judges most favorable to them because the judiciary itself, through the Chief Justice of the United States, would decide who serves on that court. And judges would bring their generalist experiences with them and acquire specialist training while serving on an Article III court of competition law. Judge Ginsburg has also written perceptively about the emerging field of behavioral economics and its implications for antitrust law. In short, he has been skeptical of behavioral economics. Price theory, in the judge's view, made antitrust doctrine rational and predictable, and the accompanying consumer welfare criterion gave courts clear standards according to which to decide cases. Behavioral economics is more open-ended and threatens to destabilize this area of law. Since the Supreme Court is searching for overarching principles to guide lower courts faced with antitrust cases, Judge Ginsburg argues that behavioral economics is unlikely to be useful to the Supreme Court. It's hard to disagree with Judge Ginsburg's contention that price theory's dominant place in antitrust doctrine is a hard-won victory for doctrinal rationality, and that behavioral economics needs to be embraced only cautiously. I am perhaps a little bit more hopeful that further research in behavioral economics can help identify irrational firm behavior and help antitrust law adjust. Judge Ginsburg's work is an important reminder that behavioral economics cannot displace price theory as the driver of antitrust doctrine, and whatever doctrine is advanced in the future, the antitrust laws should continue to be based on rational, neutral principles, just like those that he has helped usher in over the courts. The judge has also made antitrust law more rational and predictable through his work at the Jevons Institute for Competition Law and Economics at the University College London. As a member of the advisory board of the Jevons Institute, Judge Ginsburg has fostered dialogue between the US and European practitioners of competition law. He gave an address about American antitrust law at the inaugural Jevons Forum in 2005. His talk was a characteristically incisive empirical analysis of private antitrust actions, showing that the Supreme Court's Sylvania decision had caused a decrease in private lawsuits beginning in the late 70s. By starting the Antitrust Forum off on that strong note, Judge Ginsburg encouraged American and European competition authorities and jurists to learn from each other and converge on substantive and procedural principles. He continues to exercise leadership in international competition enforcement, not only through the Jevons Institute, but also through his work training international jurists through the Global Antitrust Institute at the Antonin Scalia Law School. Judge Ginsburg is also a devoted teacher. Some of you may know that the 5,700-year-old Jewish law, there's a lot of antitrust, believe it or not, in Jewish law. One of the principles is territorial exclusivity. A shop owner is actually encouraged to have exclusivity in order to have those monopoly rents to make a living for his family. However, Jewish law forbids any restrictions on teaching. Those teaching restrictions were outlawed even back then, and therefore his devotion to teaching. As many of you know, he has held a great number of distinguished academic positions since beginning his professional career as a professor at Harvard Law School. He's currently teaching at the Scalia Law School at George Mason University, and before that, he was a distinguished professor at NYU. His former clerks affectionately described their time in his chambers, as we heard earlier from Cece, as an educational crucible that honed their thinking and writing, preparing them to succeed in their legal careers and become incredibly important members, at least of this division. More recently, Judge Ginsburg has taken his teaching role beyond the walls of the academy. He performed a valuable service by creating the fantastic PBS documentary, A More or Less Perfect Union, which brought Judge Ginsburg's insights about the wisdom of the framers' constitutional design to a wider audience. I strongly recommend the documentary. I probably violated some ethics laws by recommending that. It's a fascinating dialogue with judges, historians, and constitutional scholars. It shows how our framers protect liberty by creating a government of limited powers, and how, unfortunately, federal power has expanded over time in ways that limit personal and economic freedom. Any one of these accomplishments would make Judge Ginsburg a deserving candidate for the Sherman Award. His untiring work in all of these areas has led to several careers worthy of accomplishments. And we all are the beneficiaries of Judge Ginsburg's brilliance, hard work, and dedication to public service. It is with gratitude and profound respect that I present the Sherman Award to Judge Ginsburg. Judge. We can send this to your chambers.
Oh, that's fantastic.
We can probably go over here. Would you like to give it to you?
Good point. Thank you, Nathan. That's great. Somehow I thought it was just notional. I didn't realize there would be a physical manifestation of the award. Thank you very much. I know just where I'll put it, too. I've got a prominent place in the chambers. Well, this has been an extraordinary experience for me, a little bit like awake, but being awake at one's wake. Only good things were noticed. I appreciate that. Pardon me. So it really is a signal honor for me, for anybody in our field, in our joint field, to receive the John Sherman Award, and I'm very grateful to you, Makan, and your colleagues for making this possible. Starting with Fred Young, who sang so admirably for us. This puts me in the company of 11 distinguished recipients who've received the award over the past 26 years. And I must say I'm particularly humbled by joining a list of my former professor, Dick Posner, my former colleague on the Harvard Law faculty, Phil Arita, and my former boss here at the Antitrust Division, Bill Baxter. And these are people to whom I've looked up for ever since I first met any of them, and it's really an honor to be on a list with them. And no one else on that list is a slouch. Remarkable, this is such a tight-knit community, perhaps. There's only one person on the list that I didn't know personally, and there's no one on the list that I thought was at all surprising. I mean, these are really the people who have shaped our thinking over the last 50 years, perhaps. I came to the division as Bill Baxter's deputy for regulatory affairs, and then I came back as Ed Meese's assistant attorney general for antitrust. Attorney General Meese gave me a life sentence after that by recommending to the president that I be appointed to the DC Circuit. But I never lost my affection for the division and for the men and women who serve here and my many distinguished successors as Assistant Attorney General. As you've heard, I've hired, well, no, this didn't come up. I've hired law clerks from the division, as well as encouraging law clerks who leave me to join the division. 3 of them have been mentioned. What wasn't mentioned is that Danny Hauer and Taylor Owings and Cecilia Chang each co-authored an article with me during their one-year clerkships. And that's, I guess that just reflects my selection bias in who I bring in as a law clerk, people who have an academic interest in the field as well as an intention to practice. So in the remainder of my limited time here today, I want to take up an issue that was being discussed when I came here in 1983, indeed when I started teaching the subject in the late 70s, when I left in 1986, and then after a long hiatus, again under discussion in the last several years. Now, I refer to the idea that antitrust enforcement should have as its goal something other than or in addition to consumer welfare. Getting consumer welfare accepted as the sole purpose of the antitrust law was a hard-won victory. And it came because of intellectual foundations that were laid in the 1960s and expressed by some of the people who've received this award, Richard Posner, Bob Bork, and almost to the same degree, Phil Arita, and certainly Bill Baxter. It was this 1977, after about 10 years of work on this subject, when the Supreme Court adopted the consumer welfare standard, simply saying the Sherman Act is a consumer welfare statute. As simple as that. Repeating it in 1979 and applying it ever since then, which meant overruling about a half a dozen, maybe more than a half a dozen of its own precedents over the years. Precedents that made vertical restraints per se unlawful, one after another, territorial restraints, maximum price restraint, minimum resale price minimum restraints. I mentioned territory. There are others as well. All of which were basically shown through economic analysis to be contrary to the welfare of consumers and preventing inefficient arrangements in the chain of distribution. Likewise, the application of economics and consumer welfare standard altered the court's understanding and the court's application of Section 2 of the Sherman Act with respect to monopolization and attempted monopolization, and particularly with respect to intellectual property rights. When Bill Baxter came to the division in 1981, he ostentatiously discarded the so-called 9 no-nos, the division's official list of 9 abusive practices in the licensing of intellectual property rights. And it was a good deal later, before we got to the point of the Supreme Court stating in an opinion, the possession of an intellectual property right is not the possession of a meaningful monopoly in any way. I have a monopoly over my backyard, but it doesn't give me any market power. And it's rare indeed that the possession of a lawfully acquired patent provides monopoly power that should be of concern, as opposed to being viewed as a reward for investment in innovation. Now, all of that came under question and was starting to be debated, as I say, before I got here in 1983, and the debate was originated, not surprisingly, by another recipient of the John Sherman Award, Chairman Bob Potofsky, who received the award in 2010. And Bob was concerned with the political influence that a large firm may acquire by virtue of its size, basically, and can use to its advantage or to disadvantage its rivals in the political branches of government. Corporate political influence, and particularly its use for rent-seeking, is a legitimate cause for concern. The result is too often a crony capitalism that distorts resource allocation, unjustly rewards some and unjustly harms others, and may be antithetical to the concern with competition that animates the antitrust enterprise. It does not necessarily follow, however, that antitrust enforcement is an appropriate preventive for corporate political influence. If not the only, certainly the primary tool with which an antitrust agency can inhibit corporate political influence is merger control. That is, by blocking mergers not because they are thought to be anti-competitive, but solely in order to prevent them from the merged firm from obtaining a size that's thought to be conducive to political influence. Now, there are a number of problems with using merger control to that end. First, and most obviously, it precludes realizing whatever efficiencies are motivating the merger, to the detriment, therefore, of consumers. Second, size is actually a rather poor proxy for political influence. Many small firms, and particularly associations of small firms, have substantial political clout, often besting larger firms on the other side of an issue. Consider insurance agents versus insurance companies, automobile dealers versus automobile manufacturers, gasoline retailers versus petroleum companies. These small dealers and worthy men, as Justice Brandeis might have called them, have prevailed consistently, both at the states and in the federal legislature. Finally, some firms attain size and perhaps political influence quite apart from mergers or acquisitions, but simply because they're successful in satisfying consumers. A merger control program aimed at preventing firms from becoming large would leave them unaffected. It would be essentially an arbitrary and haphazard application of the antitrust laws. Now, more recently, other voices have championed other goals for antitrust. You can hold your laughter, but they include the preservation of jobs that would be eliminated as redundant if a merger were approved, countering income inequality, preserving small and locally owned businesses, Justice Brandeis again, protecting the privacy of consumers' personal data, and environmental preservation. Here's some specifics. This is from Lena Khan and Sandeep Vaheesan, Market Power and Inequality. Antitrust laws must be reoriented away from the current efficiency focus toward a broader understanding that aims to protect consumers and small suppliers from the market power of large sellers and buyers and disperse economic and political power. Jonathan Baker and Steve Salop. Antitrust law could address inequality more broadly by treating the reduction of inequality as an explicit antitrust goal. In testimony before the Senate in 2017, Barry Lynn from the Open Markets Institute argued that the consumer welfare standard, quote, warps, close quote, antitrust law by preventing its use for, quote, specific policy outcomes, such as reducing inequality or raising the earnings of workers or fighting concentrated political power. And the most ambitious of all, this is Maurice Stuckey in 2012. If antitrust's ultimate goal is to promote well-being, we must then address what constitutes well-being. Promoting well-being entails promoting, 1, material well-being, income and wealth, housing and jobs and earnings, and 2, quality of life, health status, work and life balance, education and skills, social connections, civic engagement and governance, environmental quality, personal security, and subjective well-being. To maximize well-being, Professor Stuckey goes on, any competition policy must balance the promotion of material well-being with quality of life factors such as freedom and self-determination, while not deterring the exercise of compassion and interpersonal relationships, close quote. As you could not help but realize, hearing this litany, none of these suggestions for broadening the goal of antitrust from consumer welfare to incorporate additional objectives seems, at least to me, the least bit practical. Let's take inequality. What could an antitrust agency do about inequality, whether equality of wealth or of income? I have not found a single proponent of the idea who has laid out what the division could do to reduce inequality. I suppose it could try to inhibit business success or transactions that would make an entrepreneur rich, but that seems too absurd to attribute to otherwise serious scholars like John Baker and Steve Salop. So I don't know what they're talking about. I presume that they do, but they haven't told us. How about raising the earnings of workers, says Barry Lynn. How? By making a raise for employees a condition for approving a transaction? But perhaps the people hawking these generalities have so different a conception of antitrust that they also conceive of a different type of enforcement agency, one empowered to order wages raised, quite apart from any transaction contemplated by the Sherman Act, one that breaks up large companies not because of any anti-competitive conduct, but because they have too much political influence, or have centralized their management instead of treating geographical units as autonomous in the interest of localism. According to Professor Stuckey, it seems, quote, deterring the exercise of compassion and interpersonal relationships, close quote, would also be another antitrust offense, or perhaps just a factor to be considered against a firm in the dock for some conduct that actually has something to do with competition. What kind of decision-making would all of this lead to, or any of it lead to? At the very least, it would require an antitrust enforcer to trade off gains to consumers against losses of, let's say, employment, or against some contribution to income inequality, or against the loss of control by a local firm that wants nothing more than to sell itself to a national firm. These are all incommensurable values. Just how much should consumers pay in the form of higher prices, poorer quality, or less innovation to offset some perceived decrease in inequality, whether measured by income or wealth? There's no way to make this trade-off anything but arbitrary. Arbitrary decision-making is systemically costly. It invites political manipulation. A call from a congressman cannot turn an anti-competitive transaction into a good one, or a pro-competitive transaction into its opposite. But if the agency's analysis is readily manipulable by throwing in or out some effects on wages or localism or what have you, then every outcome can be jiggered. And even if no call ever comes, there's little reason for the public to think the agency's decisions are in fact made on some objective or at least defensible basis. Indeed, insofar as the decisions are explained either with a document from the agency or a decision from the agency or in a brief in court, there will be, pardon me, the agency will be hard-pressed to dispel the implication that it has acted in an arbitrary way. So I suggest that at bottom, the assault on the consumer welfare standard is an assault on the foundation of the antitrust enterprise. If inequality or wages or political influence should be regulated, that is a job, respectively, for the Internal Revenue Service, for a wage control board, or the codes of ethics that apply to the political branches. This is not just a plea for the status quo that I'm making. It is a plea for retaining objective criteria that can be evaluated, reviewed in a court if necessary, and where decisions can be respected as having been made on objective criteria about which people can differ. There are going to be two sides in every case and two economists in every case. But that's a very different picture than one would see in a court where the agency has made a decision based on income inequality or any of the rest. A variation on this is coming our way. It started being talked about a little more in Europe than here. Believe it or not, the European Commission has something called the Green Deal. They didn't call it the Green New Deal because we have an old New Deal and they don't. So the Green Deal is very much like what you would imagine it is. And the talk there is about the degree to which firms should be allowed to collaborate in order to accomplish the goals of the Green Deal, which have to do primarily with energy, of course, but other things as well, without running afoul of the competition laws. And this is going to be a rallying point for a great deal of agitation by firms, many of them sincerely trying to do something with other firms that would advance their government's views on the environment, but also as a guise for firms to get together and do things that they would like to do but are inhibited from doing now by the antitrust laws, not in the interest of the environment, but in their own self-interest. The European Court of Justice fell off a stool once, many years ago, when they approved a collaboration among the manufacturers of household appliances, dishwashers and clothes washers, to allow them to collaborate to achieve a standard that would conserve water. It's the only time that the European Court of Justice, to my knowledge and my research, has done anything of this sort. But it's quite clear that these arrangements will now be coming its way with the approval of the European Commission. And something similar can be expected here. The recent focus of discussion on so-called ESG, environment, sustainability, and corporate governance, is, on this side, particularly of the Atlantic, going to be the predicate for firms seeking relief from the antitrust laws under the guise of pursuing ESG. The enterprise is going to be under assault, that means from both directions, from people who are agitating for these other criteria as a general matter for enforcement, and by people who are interested in collaborating in order to circumvent the antitrust laws. It's going to be a rocky time. It's always a rocky time, maybe, for the antitrust world, but I think it's going to be a particularly rocky time for the next few years ahead. Put on your seatbelts. Thank you.
Well, Judge, thank you so much for those words. We are, just as 40 years ago, we're dealing with that, and 80 years ago, Justice Jackson, who also wandered these halls and wrote a great paper about the call for antitrust enforcement, and I believe he explained it back then when there weren't neutral principles like the ones you and Judge Bork and Aaron Director and others ushered in. I think it was that he explained to FDR when he asked him to come over and explain what the heck this antitrust law is and what are we supposed to do. And there was this whole debate about command and control, price control with whatever it was called, the Office of Industrial Policy versus antitrust. And he said the antitrust laws are as vague as the Ten Commandments and about as well followed. And back then, and 40 years later, you guys were able to usher in. It is our job to ensure that it remains principled. I think you left one of the most recent speeches on the goals or the preferred goals of antitrust, which one of our colleagues from across the street gave, which is it has not accounted for an important issue of racial equality, and it needs to be adjusted to address that. With that, I want to thank you, Judge, for all you have done, for being here and allowing us to honor you with the Sherman Award. I want to thank Justice Gorsuch for being here, and all of our colleagues who have been here virtually. It's been a challenge, but despite these challenges, I'm glad we were able to do this year. And I want to thank you again, Judge, for that, and everybody else for being here.